My name is Katie Foster. I'm a Senior Associate in the Corporate Finance practice in London. I'm here today with Nigel Wellings, who is the Head of Private Equity in the Dubai office. Nigel's going to share his thoughts with us today about structuring considerations in private equity transactions in the Middle East. So Nigel, we're obviously going to need to talk in relatively general terms, but taking the standard target for private equity in the region as being a limited liability company owned by more than one shareholder, typically members of the family that founded and grew the company, what are the key structural issues for the private equity house in those circumstances?
Well, the main issue is the need to protect your exit position and potentially enforce typical share rights such as tag, drag rights, and also share-based deadlock arrangements. The difficulty we have in the Middle East is that the legal framework is a civil law one, which means that there are many jurisdictions where a transfer of shares cannot be enforced unilaterally. And that will be either because simple practicalities, such as having to sign in front of a notary and have all shareholders sign that, or maybe a statutory reason, or even standard provisions in the articles. And of course, whilst you can write provisions into a shareholders agreement that say the other side will give you those consents, enforcement might be slow, or indeed remedies such as specific performance might not be available to you. And this means that crucially for a private equity house, their exit may be blocked, which is obviously fundamental to their commercial deal. And also deadlock mechanics, which is obviously a situation where the relationship has broken down, if they're based on share transfers, may simply not work.
So how do you deal with that on a typical transaction, Nigel?
Well, the most preferable solution, fairly obviously, is to try and impose a holding company and make your acquisition through an offshore vehicle and choose a jurisdiction where you don't have those issues. And I've done recent deals where we've used Luxembourg and where we've used Cayman. It's also useful as a slightly secondary point to try and make sure that the family shareholders come together and invest through an investment vehicle. Now, at least then the issues you have relating to individual sellers, such as intestacy and maybe one person going a bit rogue, you can remove those and have a corporate vehicle to enforce against, making at least that element simpler.
And have you found there are any barriers to structuring structuring in that way?
Well, yes. I mean, obviously, you're asking to use another corporate vehicle in your structure, so there's a small administrative cost, and perhaps the sellers don't know the overseas jurisdiction. There could also be tax leakage. Although there are a number of good double taxation treaties in the region, it's a no tax area, so any small tax leakage is a cost. But importantly, the family shareholders who are selling may simply not want to do it. They may feel that it's not right, it's a difficult conversation to have with them. But finally, the approach can accentuate the issues around foreign ownership and the foreign investment restrictions that we have in the region.
Just on that, Nigel, can you tell us a bit more about that and how that kind of impacts private equity deals?
Well, it is unfortunately a very complex area and the rules differ from country to country. But fundamentally, we do have a region where a number of foreign companies are not allowed to own more than 49% in your standard private limited liability company, although Saudi Arabia has a different regime. I think the key thing this means is that we see a lot more minority investments. So perhaps the standard private equity mantra of needing to have control, well, they have to do it through, even though they have a minority equity stake. And we see different approaches to managing that risk, but there are also some structural things you can do. There's a relatively common nominee structure, but also more complicated things like trust structures that we can advise on, and also even some of the Islamic financing techniques can be used to bolster effectively your contractual position and your minority equity rights.
Thank you very much, Nigel.
Thank you.